Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you to determine whether or not you want to contact a lawyer. Perhaps will help you to decide that you actually can handle some matters yourself. If you do need additional professional counsel, you'll be better prepared, and as a result, so will the professional you select. Our goal, of course, either way, is to help you save time, money, and achieve the best possible results. The Bazar and Associates law firm in East Providence continue to help us with each of the issues that we tackle, providing their insights and their expertise. We want to welcome again and thank Attorney David Bazar,
Thank you, Deb,
who continues to give us those wonderful bits of information, and we have plenty to discuss. Today, our topic is the anatomy of a jury trial. We've reviewed in past recent segments how to avoid a trial, maybe by mediation, arbitration, and settlement. But if a trial is in your future and it's the next step, today you're going to learn about what those steps are in the entire process, some of the frequently asked questions about jury duty, and also, more importantly, perhaps the pros and cons of jury trials, criminal or civil as they are. So are you actually in a better position to have your fate decided by what might be a sympathetic people, or maybe untrained laymen, or they're known as the jury of your peers? Does that help you? Is it a fairer trial? Even now in what is arguably a very volatile climate concerning some racial outbreaks, for example, which becomes a criminal trial? We're going to discuss these things. So David, help us out. There are things that are different, but things that are common about the civil and criminal jury trials. Give us the bare bones, the steps or the anatomy, and go through them if you would.
So we can do that. In terms of just the differences between the two, civil and criminal, the number of jurors in many jurisdictions is different. In a civil trial, the minimum might be 6 with 2 alternates. In a criminal trial, it's 12 with alternates, and depending on how long the trial might take, there may be more than 2 or 3 or 4 alternates. So the number of jurors, for instance, is a difference, and then the process is slightly different, but not totally different. So maybe we just take an example.
Tackle one.
Yeah, and so let's start with a civil situation, and there's an incident. And the incident is the case that gives rise to the jury trial. So in this case, we'll take a hypothetical auto accident. So the person has the auto accident, they treat, they go through all the processes that we've talked about before, where the case is worked up for settlement, the case can't settle, it's put into suit. So now the case is put into suit, and you go from the incident, you might broaden it out for the defense lawyers who want to defend the case or asking for every piece of information under the sun. There are depositions, all of that discovery, the funnel widens out, and all the possible information is put into the case.
So when you think about how a trial starts, and you're using the example of an auto accident, there's always a start of choosing a jury.
Well, we haven't gotten to that yet.
So, but that's a basic step that's common to both.
That is common to both.
That may not be the first step, but that's one that's ready to happen, right?
Right. So well, let's work our way there.
Okay.
So here's where we're at now. We've gone through the discovery, and now we've tried some of those alternative dispute resolution processes we talked about before, whether it's arbitration or mediation or settlement conference, pre-trial with the judge, whatever it is, it hasn't worked. So now what we start doing is narrowing the funnel. So it's sort of like the diamond, and we're getting now issues narrowed for trial. So the attorneys, before they go in for the trial, might want to meet and try to say, well, let's narrow the issues on what we can agree on. So maybe there are some issues that the 2 lawyers can agree on, and they can stipulate to those. So a stipulation might be written up, whereas the plaintiff and defendant have agreed to the following facts, and you can list them out. You might pre-mark exhibits for the trial. You might be able to agree, yep, that medical record's going in, that phone log is going in, the police report is going in, whatever it is that you have may be agreed to or may not be, so you can narrow those issues. So now You get called to court, the judge wants to meet with the two lawyers before the case starts and says, all right, what have you been able to agree to? Yep, I agree with those stipulations. Those exhibits can come in as pre-marked. Now there might be some issues which are pre-trial that haven't been agreed to. And for those, the lawyers might file what's called a motion in limine. For example, there might be some medical records in this auto accident case unrelated to the accident that the plaintiff's lawyer might think are so unrelated they shouldn't be allowed into evidence. And the defense lawyer says, well, you know, that might impact pain and suffering.
Pre-existing or something?
Could be a pre-existing condition. So obviously, maybe not so obviously, if it's a pre-existing condition of the same type of injury that the person suffered in the accident, probably more likely than not that's admissible and relevant to the trial. But if it's a pre-existing condition, say a psychological condition that has nothing to do with the back injury, and you're not making a claim for psychological or PTSD damages, might not be related and shouldn't be admissible. So those are where different motions in limine might be filed. It can be about a number of other things too, preliminarily. Go ahead.
So while this is going on and we're talking along the lines of a trial, would you concurrently still be trying to perhaps settle? Would that still go on at the same time? Because as you get closer to what you agree on, maybe there are more things that you can agree on that point to, we really don't have to push this final button.
You're always trying to settle, both sides. It's always usually in your interest to decide the case yourself before the jury tells one side or the other who's right and who's wrong. So that's always the opportunity. But we've come to this point because all of that has sort of failed, the mediation, the arbitration, the settlement conferences you may have had. So now we're literally days before the trial. And I'll talk about picking the jury, which may have already happened in some cases. In some jurisdictions, it hasn't happened. Some jurisdictions, they pick the jury, you know, a week or a month in advance. And then they say, come back, the trial starts on such and such a day. And in between, you're doing all of these pretrial motions or other things preparing for the actual start of the trial. So I'm taking a case where we haven't picked the jury yet. We're still doing these preliminary motions. And now all those motions have been decided. The only other motion I might mention is what we call a Daubert motion. It's a motion about whether or not expert testimony might be admissible in a case. And Daubert is based on the name of a Supreme Court case that talks about what needs to go into the judge's decision in making the relevant findings as to whether or not the area that the expert is testifying in is reliable science. And they sort of call the judge or the gatekeeper in deciding what type of expertise is admissible and what type of science is admissible and all of those things. So if it was a products liability case and you might have an expert who has expertise in quantum physics, probably a well-recognized science, and you might be able to just agree if you don't have a Daubert issue on that, whereas it could be a science that's a little bit less agreed upon as to its acceptability, and the judge has to make a decision on whether or not it's relevant to this case and acceptable science. So that's pretrial motions. And
if you're defending someone at this point, you're saying that possibly the jury is being selected, and you have an idea of who might be sitting as the judge. Might those things color in your own experience? I like this jury. Obviously you try to get the best possible jury, but I'm not really sure I like this jury. I'm not really sure I think this judge has it all together in my case here. I'm not sure I like that. Does that impact on or color how you will guide and direct either a settlement or taking it to trial?
Well, once you get to that point, it will. But so here, we're going to get to that point for you right now. So we did all our pretrial motions, and now we're going to pick the jury. And that is a science.
Yes.
And
TV says so.
They could do TV shows on it, right? So there's a lot of different ways to pick juries, and in most cases, you're not going to spend the money to hire a jury scientist, so to speak, a jury expert. In bigger cases, people do that. That's real life things, and that happens. But for our auto accident that we just had, we're going with our experience and our history of what we've seen juries do and who makes a good juror for the type of case we want. So now we're at the point where we pick a jury. So what happens, and every jurisdiction's slightly different, so we'll just take Rhode Island Superior Court, and each judge could be slightly different even there. They bring the jury pool in, and they have a bucket of ping pong balls with numbers on it that correlate to juror's number. And juror number 12, please come up, just take a seat. And in some cases, you start with the judge. Well, the judge will explain to the whole jury pool, this is what this case is about, this is the type of situation, et cetera, et cetera. And then they start calling up the jurors and they put them in the box, and you, as the attorneys, now are going to conduct what's called voir dire.
Voir dire.
And voir dire is where you are allowed to explain your case to the jurors, try to get their opinions on civil cases, and if it's an auto accident, and awarding money in a personal injury case, and if they've been involved in these kinds of accidents. So you get up and you basically say, this is our case, these are the people involved, these are the experts you might hear from, these are the other witnesses that you might hear from. Does anybody know anybody? Let's just start with that, because, you know, in Rhode Island, it's Rhode Island. And
1 degree of separation.
Yeah. Oh yeah, that doctor's my cousin. Well, that might be grounds for them just to be off the jury in and of itself. So you get a certain number of challenges called peremptory challenges, which is for not cause, but there's challenges for cause too. So if one of the jurors is related to one of the parties, obviously the judge is going to excuse that juror. If there's something not quite that close, but somewhat close, the attorney on the other side can move to challenge the juror for cause and say to the judge, that juror really has a predisposition to this case and shouldn't be allowed to stay on. So the voir dire is actually the lawyer's first opportunity to start swaying the jury.
Do you ever find that what we see on television, that some questions seem so unrelated to the case as to be, they seem irrelevant? Do those things happen at all, David?
Sure. And it is a way of trying to get into somebody's mind to see what makes them think and how they feel and how they respond to certain things.
Or their prejudice, perhaps?
Perhaps, yep. But you got to be careful, though, in how you do that. Right. So when you're going through those questions, those are the voir dire questions. Those are questions that you have to be very careful about, number one, how they're related and what you're going to try to get out of the person you're asking the questions to. And the best questions aren't yes or no questions. The best questions are
open-ended.
Open-ended. How do you feel about? What do you think about? And you want them to be able to say what they think. And maybe they'll say something and you're looking at another juror and seeing how they react. So you might go from that question to that juror to that question. I saw you had a reaction to that. What do you think about that? And you're trying to get the jurors to say as much as you can, and the judge will try to control this a lot, but you're trying to get them to tell you what they think and how they think so that you have a better idea of how they might respond to your case.
So are you saying, as one who's asking the question, that you're not only posing the question, but to some extent you're trying to, well, open someone up and have them be self-disclosive, but also getting a body language read from the other 11 or however many that are sitting there?
Yes. Yes.
Okay.
And you know, I love when I'm not the one doing a trial, to watch a trial so that I can watch what I see in that voir dire process and then watch the trial itself and see how they react to the witnesses to get an idea or a sense of, was I right about what I thought about that juror going in as the trial was being presented. And just watching jurors' body language tells you an awful lot about how they're reacting to a case. And it's not easy if you're the attorney trying the case to try your case and watch the jury at the same time because there's too much going on. But if you can, and I'd always try to, if the judge lets me, position where I'm asking questions from. So after I ask the question, I can watch the jury and get a sense of what they're responding to and how it's going. But you can't always tell. But you usually can really read somebody's body language as that's going along. So the voir dire is really about learning who these people are and what makes them tick and how they react.
One other question. So while you're questioning them on the one hand, suppose the person who's being questioned or is about to be questioned is hearing your line of questioning and whatever, and it feels, I should definitely not be serving on this because I already have an opinion about the whole, or I read too much, I want to be excused. Does that happen often?
Sure.
And do both sides usually immediately agree to that?
No.
She said, knowing.
Right. And so
gonna say.
both sides don't always agree whether someone should be off. And the person who often doesn't agree is the judge. And the judge will ask his or her own questions. And the judge asks a lot of questions too. And so they'll explore with the juror. If a juror is trying to get off a case, the judge will explore with the juror. So, you know what do you think the most common excuse for a juror to try to get off is? Out of jury service. They don't usually use the I'm prejudiced about this or that kind
I'm
of
ill
thing.
or I have a business, so they don't even want to be there.
Right, work. And a recent jury being selected, a young teacher said, I don't think my business will let me stay away for the school for 2 weeks. I've got young students and they're used to me and et cetera, et cetera. And the judge said, give me your principal's, or head of school, I think it was principal, give me your principal's name and telephone number, and I'll call them up and I'll explain to them why it's important for you to have your civic duty fulfilled here today.
Jurors, what do they get paid these days for
It
serving?
depends
$40?
where they are. It's not, it's lunch. You don't forget, sometimes they get lunch when they're deliberating. But if it's not deliberations, it's enough maybe to pay for lunch.
How about if I can't afford to be serving the jury? I need to work, someone says.
Yeah.
Do they get out for that
No.
reason? No.
No.
So don't try it.
No,
Tell
you
our
can
viewers.
you try whatever you want, but
But it's supposed to be a wonderful experience to be doing this.
It is, and it's your civic duty. It is. So, okay, let's say at this point we've selected our jury. So what do we do next?
What do we do next? Opening statement?
Civil case, opening statements.
Okay.
Right. And so here's what most attorneys like to do. For whatever reason, you've finished selecting the jury, you stand up and say, the jury as constituted is acceptable to the plaintiff. And then the defense will say the same thing, because we both want to be the ones who really accepted that jury, and that's the jury we want. So, civil case, the first person to open is the person who has the burden of proof, and that's the plaintiff. So the plaintiff will lay out their case, and what an opening statement is, and if it's a good opening statement, is a story. But what it's not is an argument. You're not arguing to the jury, this is what the evidence showed, and this is what we proved.
It's not facts, it's based on your feeling and your case that you built?
No, it's about, these are the facts we're going to prove.
As you want to present
the
it.
opening is, this is what we're going to prove, and the close is, this is what we did prove. Mm-hmm. The difference is, you're really, if you're really stuck as a lawyer, just you go through each witness and say, this is what this witness is going to say, and this is what this one, it's not really exciting to the jury, and you want to hook the jury right from the beginning. Mm-hmm. So it's a story, and you tell them the story. And of course, along the way, the judge might get frustrated with you if you're doing a little bit more.
Get to your point?
No, it's
No. Okay.
more of, that you're venturing into argument rather than fact laying out, explanation. So, well, this witness will say, and then you tell your story again. And so you're telling a story, and you're telling the jury the story of what the case is about. If it's this auto accident we started with, how my client was perfectly fine, sitting at a red light, minding her own business, and if out of nowhere, the defendant came, smashed into the back of her car, and changed her life forever. And here's how it changed her life. And these are the things she can no longer do. And these are the things that she suffers with every day. And these are the things that really have changed her life in a very meaningful way. And so you just start laying out that. And how am I going to prove that? Well, she's going to testify, and the doctor's going to testify. And the doctor's going to tell you that the surgery he had to perform required anesthesia, hospitalization for 2 days, and then graphically he's going to show you what he had to cut out and remove, and the hardware he put in, and how this is going to impact her every day. So you're laying out your case. The defense can choose to open after you do, or they can wait until they have to present their case, because the defense doesn't have to prove anything, the plaintiff does. Usually, most defense lawyers want to open right away because they don't want the plaintiff running too far out in front of them with the jury and telling the jury, you know, this is the case, without them telling, wait a minute, you know what, that back surgery, she was going to have that anyway, and here's how we're going to prove that. So, the opening statements.
Okay, and then what happens?
So now we have to start with the
Facts.
evidence, right? And so the judge will give some instructions beforehand, and the judge will give instructions, probably, depending on the judge, before the attorneys do their openings, and the judge might tell the jury, you're going to hear opening statements now from the lawyers. This is not evidence. This is their opportunity to tell you about their case, but all of the evidence that you will consider will come from the witnesses and evidence that is introduced in the case. And so after we have done our opening statements, now we have to present our case. So the direct case of the plaintiff is presented first.
And would you ever find a judge these days ever, and I don't want to digress, but ever giving them insight into what jury nullification is? If you
No.
don't think this is right, okay.
No.
We won't, we'll save that for
Yep.
another day. Keep
Yep.
going.
Yep. So now you're calling your witnesses. So first witness comes up, might be my client. So on that bright sunny March afternoon when you were driving to work, tell the jury what happened. And so I was stopped at a red light, and you go through all of the evidence. It's direct examination. You can't lead your witness. The witness has to answer the questions. Usually they're open-ended questions, but you've prepared your witness for the questions that are going to be asked, so they're ready to give their answers. It doesn't always work that way. Sometimes you have to ask the question again and remind them in a gentle way so that you're not leading them. Well, did anything else happen? You know, oh yeah, I got rear-ended. Okay, good. So you're presenting that witness. When you're done, the defense attorney can cross-examine. Cross-examination is not leading questions, but they're questions that are designed to give the answer. Like, you weren't really stopped at the red light, were you? You backed into my client. No, whatever. You had a prior back injury, didn't you? And you were still treating for that. You're asking questions you already know the answer to, obviously, and you're closing off doors so that the plaintiff, or I should say the witness, can't escape out. You're narrowing them in. That's cross-examination. And after they're done cross-examining the first witness, you're allowed to redirect if there's anything that they brought up, and then they can recross on anything you brought up.
Is it part of your strategy, or the other side's strategy, whichever side you're on, for you to phrase a question that really isn't a question because you just want to get a point across, even though you know that it will be objected to, still the jury has heard it, and even if they say the jury will discount hearing that, you can't unhear something? Is that often a viable strategy?
It happens. You can't unring the bell, as you're saying. Most times, though, you're trying to really get the evidence in that way you want. There are times where the judge won't let it in. You keep asking the question, the judge keeps sustaining the objection, the jury gets the point. You don't want to do too much of that, though, because the jury doesn't understand, and the judge will instruct the jury, but the jury doesn't always understand that it's okay to ask a question that's objected to and sustained. It's part of the process. But you don't want every question you ask to be objected to because you put no evidence in, and you don't want the jury to think that what's going on here, the judge doesn't like him or something.
Okay, what happens next? You're at a closing next, or
No, we haven't
More?
even finished the second witness.
As the time clock ticks
All right.
on.
We ask we present the rest of our cases, and the evidence can be, as we said, the evidence of the testimony of the person, the exhibits that you want to put in, the medical records, the x-rays, the MRIs, whatever else needs to go in. You present your case, you rest. So now what happens is the defense attorney may move for a directed verdict, that they want the case dismissed. Who has the burden of proof? The plaintiff. Did the plaintiff prove their case? Nope, they didn't prove their case. So the judge will look at that. It's a high standard, and the judge will determine the motion is granted, not usually. I'm going to withhold my decision on that, you present your case, or denied. And so now the defense can present their case. Same process, witness, they do the direct, the plaintiff's attorney cross-examines them, back and forth you go. They finish their case, see how much quicker I got through the defense side of the case.
Yes.
And now both sides rest. The defendant may again move for a dismissal. The judge may again say no. Now you can have your closing arguments.
Which is?
Now it's a summary of what happened, but again, it's a story. I told you at the beginning of the case, this is what we're going to prove, and this is what we did prove. And now you're just summarizing all of the evidence in a very dramatic and nice way so that the jury can make their determination of what happened. But what happens in this process is you're arguing what was proved, and you're, as a plaintiff's attorney, making suggestions to them as to how they ought to award damages. But you have to be careful, again, now, not to step on the judge's toes, because the judge gives the jury instructions. So while you may want to say some things that they need to consider, you have to be careful how far you go. For instance, how do you award damages? Well, you have to determine based on your own experience what you feel it's worth to have to undergo back surgery and to no longer for the rest of your life be able to do the things you did. Is that worth $100 a day? Is it worth $200 a day? What would you feel is fair compensation for that? And you can actually have math and put it on a board for them and say, well, if you think it's worth $200 a day, here's what the value is, because here's the life expectancy we proved that this client of mine has to live with these problems for the rest of her life. The defense does their case, then the judge gives the jury instructions.
Do you want to elaborate on that for a moment?
I do.
I'll
I
bet.
didn't know how much time we had.
Not much, but this is worthwhile. You
so
really
the
do
jury
need to cover
instructions
this.
are the judge is now going to instruct the jury on all of the law that's applicable to the case. So in an auto accident case, there'll be instructions on burden of proof. That's on almost all civil cases, and the plaintiff bears the burden of proof. And what does that mean? It's not beyond reasonable doubt, and the judge will explain what we have to prove. The judge will explain negligence and what we have to prove and all the elements of negligence, damages, what we have to prove for damages, what they're allowed to consider, et cetera, et cetera.
Then they deliberate, they decide.
Yep.
If you like, it's good. Otherwise, they appeal. Is that right?
So the jury comes back with its verdict, and you can file motions again, post-trial, motion for additor. The jury found that they were responsible but only gave us $100. The medical bills were $5,000, this was that. It's not enough money. We either want a new trial, it's like a motion for a new trial, or for the judge to add money. The defense attorney may come back and say they gave way too much money, here's what it should, reasonable, take money back or new trial.
Thank you. I wanted to ask about the pros and cons of having a fair and impartial jury of peers. We might need to discuss that in the next section. We hope that this has been helpful to you in your understanding of how a trial by jury operates. We thank you for tuning in to The Law Matters. Stay tuned because the law matters to you.